And who's there for the petitioner? Who's there for the?
I'm appearing in item 4, my lord.
No, 4 is already over. Interpleader.
4 is over. This is number 6.
My, okay, my lord,
Interpleader.
You are in item number 4. You are for whom?
for petitioner, my lord, there is settlement going on in this matter.
So we have already.
Bhavna Khowal.
2 weeks. We have given 2 weeks time to file
142 applications.
142 applications.
Highly obliged.
Item 6. Who's there?
Mulaj, I would like to withdraw this present petition.
You want to withdraw? Okay.
Yes, Mulaj.
Item 7.
Madam, I'm appearing for respondent to the point. Petitioner is seeking a transfer of guardian petition from Indore to Ludhiana.
Huh?
No one.
Just pass it.
I appear for the respondent. This is the matter in this petitioner is seeking transfer of a civil suit.
Why civil suit to be transferred?
What has happened? After my marriage, my husband had left to the USA, and when I went there, he involved in certain immoral activities. He forced me to that. I somehow returned back. My in-laws just filed a civil suit against me and my husband, disowning him and for permanent injunctions. Now the problem is, I am residing in Haldwani. I'm unemployed. I'm totally dependent on my parents.
Haldwani to Karnal is not very far off, and you are a defendant, no?
No, I'm the petitioner. In civil suit,
In the civil suit, she is the defendant.
You are the defendant.
And the property is located in Karnal.
I also understand it's a civil suit for lordship.
Sorry.
Then permit, ask them to pay the traveling expenses whenever my.
I am not the husband. And plus that.
Civil suit you want? Expensive.
The petition was service is complete.
Wife, you are the wife. Transfer.
The wife seeking transfer.
Service is
Services
unserved.
in fact it has gone to him. The
Insufficient address. Second, also no such person.
So calculate the service of the.
that was the service. Yes.
Transfer. Service is complete through trial court.
11.
Profit court.
Item number 11.
Yes.
I appeal for the respondent. Well, if the other party agrees, we could send refer the matter to mediation.
Yes, Mr. Counsel, what do you say?
Usually, I am appearing in item number 11, Your Lordship.
He says mediation. Husband says mediation.
So, my lord, mediation can be done in Jalan only, Your Lordship.
Why? Why not here in the Supreme Court?
Could appear with BC minus.
First through VC unless the mediator.
Here in litigation expenses may be given, my lord. Then.
Sorry.
How होता है if you have to travel होता है mediation.
Yes, sir.
Supreme Court.
Hello.
Item 12.
But who are the petitioner transferred to Agra to Jabalpur? That was petitioner.
The only thing is that look at the counter they have filed. They have said that you are very well. You are very well.
Counter is an election document. Nothing. I am service. I am very job.
You are working also, na?
My father is a petitioner. Father is a cancer busy. Admit in Jabalpur. Therefore, I am seeking transfer. Election. Cancer busy last time.
That's all right. Sorry. Normally we allow not, but not in this case.
But we see last time.
That is, okay, you're not inclined to interfere. However, liberty to the petitioner to approach the court for,
Nothing, one matter is pending, maintenance pending for Jabal Hilal.
or having the proceedings conducted through VC, subject to convenience and orders passed by the court.
Item 13.
Subject to availability of the infrastructure and the orders passed by the court. Yes, next. Yes,
Passing. This is a short passing.
also,
यहाँ से एकदम शायद पास होगा.
Item 14. Matter is about 650 ml beer, Your Lordship. The same was found in my car, and I was unfortunately the owner of that.
Rana.
I'm grateful.
counter there is a charge sheet.
And for the state.
Service is not complete. That's on the private respondent.
It's not complete.
It's not complete. It says
I go to state.
As per official report, respondent number 2 could not be served. Fresh steps for service be taken. Service in relation to concerned assessor.
I'm so grateful. Lord's interim order to continue.
Intend to continue.
I'm so grateful.
Your Lordship. This is a case for construction.
State of Rajasthan. We just pass it over. You're there. What do you say? Okay, no problem. You file a reply.
Yes, sir.
See, for 9.5 years he's behind bars.
It was only 2 weeks.
2 weeks. 2 weeks. No more. It's gone.
Item 17.
So this is complete the statements. They have filed a workout.
You just pass it over.
Wait, please, Your Lordship.
Yes, please.
This matter comes up after notice hearing. My friends have yesterday filed a counter affidavit. They were present here on 23rd May.
Yeah, we filed it, but I don't think the state has filed its counter affidavit at the moment.
State, counter of the state is there, but
We've not been served.
State has not filed a counter, Your Lord. Respondent number 2, my lord, the private party, the complainant has filed.
As per the office report, they have not filed. State.
So what do you say?
Well, we are ready to argue, but the state has to be heard.
But you are the complainant.
I am the complainant.
Why should we not grant bail?
Well, that's Lordship sees the earlier order of my lords. Order dated 23rd of, this is the impugn order. Lordship has an extra P10. The petitioners got bail earlier. We came and challenged before this court. This court set aside that order and remanded back the matter to the High Court for reconsideration because the essential ingredients of Section 21(4) of Makoka were not considered. Now, but after that, this order has been passed by the trial court. The petitioners are the main person and who had actually engaged those hired assassins and who had then shot dead the deceased. That's the husband of the respondent number 2. Lordship, may kindly have an extra P10. This is the earlier order of this court. They were granted bail by the High Court and then we came to in the XLP. Lordship has page 232.
This one.
Lordship has page 232.
232.
232, my lords. An extra P10.
Yes,
Lordship has it.
we have it.
Lordship notice,
Yes.
para 4, it is a core contention of the appellant that the bare producer of the impugned order itself will bring home the fact that order granting bail to respondent number 2 and 3 in case of Makoka is an outcome of consideration akin to a mini trial.
So we had only remanded the matter.
Remanded the matter and then the trial court recalled its order, which was actually set aside and they did not grant him bail. So now it's a case where they have not been granted.
The trial court, my lord, it's the
High Court, sorry, and now they are seeking
No.
bail before my lord.
One thing is there, subject to correction.
Please, my lord.
Even while we remanded, we did not cancel their bail.
Please.
We said yes, he will continue.
See, what we are saying is that page 24243, even while we remanded the matter,
Right, sir.
we did not cancel his bail.
Yes, my lord said that the order granting them bail will continue till the decision and the matter be decided within 1 month. Now, this order was extended by the trial court, High Court by granting bail.
Correct.
But when we came up on the after notice matter, this court directed them to surrender. The lordship has the last order. There was no exemption from the surrender granted. So on 30th June, they have surrendered. I believe they have filed a additional document showing the certificate of surrender. So today they are in custody. And my lords, what has happened is, it is within 3 years they have been granted bail. So Article 21 also will not apply, then it's a delay.
It is a family dispute. But
It's not exactly a family dispute, my lords. It's a case where there were property disputes.
property dispute.
But the fact is, you cannot take the life by hired assassins in this manner. And there is lot of video, we see video capturing, which will show that A1, A2, A3 and the petitioners came out. Petitioner was taking the fruits and there is a communication between the hired assassins and the petitioner, and I will place everything on the court.
Madam, just one. See, we are asking ourselves, there are 17 litigations pending intercede parties. He's behind bars for how long?
Malad, it was less than 3 years. Malad.
Sorry, bail was granted after 3 years and 1 month. And now, my lord, again 2 months I have been in jail. 3 years and 1 month.
3 years and 1 month, Malad.
For both the brothers. So my
So
friend
now
is making a wrong statement.
6 November 23, they were granted bail. They were arrested on 6th of October 2020, and then they surrendered only on the 30th of June. So 1 month now and 3 years.
2 months now. Please have your calculation right. Sorry.
June end, only July is over.
Wait.
Or it's still to be over.
Sorry.
My correct calculation.
This, we don't like this.
Sorry.
We are putting it to her.
I'm sorry.
You have your
I'm very sorry.
say.
Very sorry.
Correct her. No
Please,
difficulty.
please.
So 3 years, 1 month was before the release and 1 month now.
When this court cancelled the earlier bail,
Please, my lords.
remanded the other,
Right.
suspended the earlier order, court consciously did not cancel the bail.
That's quite
Therefore, the court
Then-
said that please re-examine the issue. Now, in this view of the matter, we are telling you that when two warring groups
It's not a,
pertaining to
with all due respect, my lords, it's not a case of warring groups. It is a case where there is a litigation, no doubt, but you can't hire assassins to take.
allegedly.
No, allegedly, no, because there is lot of evidence. The lordship is there are emails of attacks, there are phone calls. I can place everything on record. I can find all those documents on record.
Having heard learned counsel for the parties, I will also present the record. Yeah, they consider you that the attending facts and circumstances, more so considering the earlier order passed by this court, with a earlier judgment dated so passed by this court, with page 240. The petitioner is entitled for
The second January 25.
entitled for the relief paid for in the present petition. That is, as such, we direct the petitioner to be enlarged on bail on such terms and conditions as may be enforced by the trial. Needless to add, What is the stage of,
Well, that's my respectful submission.
Charges have not been framed.
Because they are delaying the trial.
One-
In fact, the APP has filed an application.
we are saying that.
No, APP is filed and that there be for expedition of trial, but they are not.
We are saying, we are saying.
Because I have been put the state, the next date of hearing is 14th August, notice.
Of, for,
For framing of charge.
needless to add, framing of charge means the investigation is complete.
Yeah, charge sheet has been filed.
One by one, we are asking.
Charge sheet has been filed, my lords.
No, so it has got to our notice that Challan already stands presented. And the matter is now listed for hearing on dash
14th August, my lords.
41 for framing of charge. So, we direct all the parties to fully cooperate. Cooperate during trial.
Let's fix a time frame.
We are saying trial is expedited. We request the trial court to conclude the trial expeditiously.
Preferably within. Preferably long.
The expedition is good enough. We, needless to add, party shall fully cooperate. Should the trial court find the accused not to be cooperating in any manner, it shall be open for the court to take all steps. Please cancellation of bail in funds of law.
Very grateful.
Deeply obliged to us.
Only for information, Virat, just to like say, I surrendered on 31st May, not 30th June, and I have annexed a certificate order of the court. And also the charge sheet was filed here in 2021, Virat. 4 years, more than 4 years ago.
And it's their discharge application which is pending for these 2 years, which they are dragging. I can place the orders on record.
Lordship, very good.
Blind.
So this is SLP.
I need to pass over.
Pass it.
Great.
Pass over will come immediately.
It's coming up. Notice, Your Lordship should notice. It's on 2nd of June, we'll see. I'm a 19-year-old girl, and not named in the FIR, nothing against me, even in the confession, no role, nothing of the kind. Please see, Lordship, you see, page 2021, as far as I'm concerned.
You're not only on the basis of the confession of a co-accused.
And that too, one line that I hold it around, and 19-year-old girl,
Lordship, there are a couple of submissions. Your Lordship may have the counter affidavit which I filed. First, the charge sheet being filed in the matter. In terms of what is weighing in favor, yes, there are no criminal antecedents. I don't join issue on that. However, there are certain other aspects. It's incorrect to state that the person has no role. It's explained in detail. Your Lordships may have para 13 and para 14 of it. In terms of this, what is emerging, Your Lordships, is that there is a certain element of premeditation